or a beneficiary and you're trying to determine what to do. I often have people come into my office and they think that they can take that will straight to the bank or straight to the title company to have assets transferred. But there are many more steps to handling a will, and it's called the probate process. And in this video, I'm going to discuss with you some of those steps that must be taken care of in order to have a will validly probated and administered. My name is Rebekah Coquat, and I am one of the founding owners of the Coquat Law Firm. You are watching Coquat TV, Estate Planning and Probate Edition. So you've had a loved one that's passed away, and you've found their last will and testament, and you've noticed that your name is in there, either as the executor or a beneficiary, and you want to figure out what to do at this point. The first thing I would recommend that you do is contact a probate attorney that is very familiar with the estates code here in Texas. And that's what we are here at the Coquat Law Firm. And we would sit down with you and determine how to go through the process of the probate with you, depending on the situation with the what kind of will you have, what kind of assets are in the estate, and just all the dynamics that are around the estate that would help us to determine how to handle the probate for you. So if you're looking for an attorney at this point to help with probate matters, I would highly recommend finding an attorney who handles specifically probate matters. There are so many attorneys out there, and we all handle specific different things that we are very good at, and but I would recommend that you hire an attorney that's very familiar with probate matters to handle your probate situation. In Texas, we have the estates code that specifically sets out the laws that say how probate matters are taken care of. When you hire an attorney that handles probate matters in Texas, they're going to be familiar with the estates code. They're going to know how to streamline the process, how to follow the timeframes correctly based on the estates code. And if you hire an attorney that's not familiar with the estates code and the probate process, things might just not go as well as you would like for them to go. So once you've hired the probate attorney to handle your probate matter, the attorney will file the appropriate documents to start the process with the court. And that's going to be the application and the original will, last will and testament. And there will be a short waiting period before an actual hearing is scheduled. After the waiting period, you will have a hearing with, you and your attorney will go to court and appear in front of the judge, and the judge will determine that the last will and testament is valid and that it will be an independent administration or a dependent administration based on the last will and testament, along with the application and what the attorney has asked for. And that will most likely be the only appearance you have to make with the court in a straightforward independent administration. There will be specific documents that your attorney must file with the court during the administration process of the probate. One of those documents is called the inventory. Generally, the inventory must be filed with the court, and the inventory will discuss what are the assets in the estate. We will specifically set them out and the general fair market value of those assets. And that's where it gives the court a general idea of what the estate looks like and what's being administrated. It will be a public record because probate documents are public records, and the other beneficiaries or creditors are able to access those public records and see if there's any reason why they would be involved with the assets that are in the estate. With the inventory, there is also a document that frequently we are able to use, which is called an affidavit in lieu of the inventory, where we are able to ask the court to allow us to keep a general inventory confidential. So so it would not be part of the public record. And that's kind of advantageous because then you don't have it where just anybody can see what's part of the estate. We're seeing that we can use those frequently, but there's certain times when the court does not allow those. So one way or the other, you have to have the attorney file a document in regards to the inventory. After you've probated your will, had the court, which is having the court determine the will is valid, then the administrative part of the probate begins. And that's going to be where the executor goes through and basically figures out what the loved one had. Goes and hopefully there will be a list of these assets, but there might not be a list. So it's a fact-finding event at that point where we go through and we see where were the bank accounts that the loved one had, what kind of life insurance, medical insurance, just anything that would help us know what that loved one might owe, and what they had, what kind of real estate did they have. And so that's the beginning of the administration, is just finding out what is in that loved one's estate. Then you go through and you contact those different companies, the life insurance company or the banks, and let them know, I'm the executor. Your attorney is going to have what's called letters testamentary or letters of administration, depending on how the administration is set up. And we would send the proper documentation to the different companies to tell them that you've been appointed as the executor or administrator. And then it's a kind of a paperwork time at that point where you would fill out whatever that company needs you to fill out in order to send you the money, send you whatever is left over in somebody's bank account, close out bank accounts, and just generally administer the estate and take care of everything in that. And it's the process where you're, I like to say, kind of gathering up all the assets into a big pot, and then that allows you, once you feel comfortable that you've gathered all the assets and dealt with creditors, then you're able to distribute the different assets to the different beneficiaries, depending on whether that's liquidated assets or certain real estate, however the will sets out for you to handle that. I do have a few different examples where I've had executors come in and they've found the will initially, so we've gotten them appointed through probate, but then they start kind of digging through their parents' house that has lots of papers, and they find a lot of other assets that they didn't know, like other bank accounts or bonds or things like that, where once they're received access to the files, they're able to uncover a lot of assets they didn't realize that they had. And then even just sometimes the fun stories that I hear about going through the jewelry boxes or the coin collection, or something special that their parent had or their family member had, that they're able to go through and then make sure that if the will says who that jewelry goes to or that coin collection goes to, they're able to give it to that person. And that's kind of a special event for to happen. And I've enjoyed watching those types of things as well. I guess when you have real property in an estate, then once you've probated the will and it says who the real estate or just generally assets would go to through the will, then you're going to need to have that will and the order that the court has signed, validly probating that will. You're going to need to use that as your proper documentation to be able to have a deed prepared for any type of title transfer of that real property. If you haven't probated the will, you're not going to be able to do a valid title transfer in most situations for real property. Another thing is, once the will is probated and the executor is appointed to be able to do the administration, they are able to act on behalf of the estate at that point, and they can sell the real property or deal with the realtor. Until you have the proper letters testamentary, which you receive through probate, a real estate company, a title company is not going to work with you on selling real property or selling that asset. So it's very important that you do the first step of the probate before you can do that administration of the real property. That's probably one of the biggest things I see come up, where people come in to me and they say, I'm trying to deal with this realtor. I've got this will, but I tell them, well, we have to probate that will in order to follow the proper steps in order for you to be able to sell that real property or transfer that real property to whoever you want it to go to. One of the main ideas I would like to share with you is that there is a proper chain of steps that must be taken in most situations when a loved one has passed away in order to handle their real property or generally the assets of the estate. And that's going to be probating a last will and testament if there is one, or dealing with a estate if there's not a will, but going through the probate process. Then you can do the administration, which would be gathering the assets and liquidating them or distributing them outright at that point. But you have to follow those specific steps. Otherwise, you're going to get caught up in not having the right paperwork or the right authority to be able to act on behalf of the estate if you haven't gone through the probate to get the documentation to show that you are the executor to act on behalf of the estate. So that's one of the main issues I see when people haven't come to me from the beginning of right after someone's passed away. They come in because they're stuck and they're not being able to sell the assets or transfer title or distribute things out. It's because they haven't been given the proper authority to begin with to be able to take those actions on behalf of the estate. And that's what a probate attorney is going to be able to properly take you through every step that needs to be done, so you won't get caught up or stonewalled by the title company when you're trying to sell a house, because we will make sure that you have that proper documentation to take care of those types of things. If you've learned something new today, we would like for you to subscribe to the Coquat TV YouTube channel. Also, if you have a specific legal question or a specific probate matter that needs to be taken care of at this point, please call our law firm. We would be happy to help you.